Good morning, everyone. I think it's good morning. Good morning. Thank you so much for joining us for the Bench and Bar Committee's Lunch and Learn. We're really happy to have everyone here this morning. My name is Vania Allen. I'm the Chief Deputy for Operations here at the U.S. Bankruptcy Court in Northern. And I have the esteemed pleasure of serving as moderator today as we shine the light on ECF and provide some practice pointers. Before we begin, I'd like to introduce our panelists. Immediately to my right is Stacey Jones. Stacey is the Deputy in charge of the Rome Division. She's been with the court for 27 years. Many of you have probably spoken to Stacey on the phone before and probably thought to yourself, she sounds so happy, and she really knows what she's talking about. I'm happy to say that she really is always that happy, and she really does know what she's talking about. Next to Stacey is Kimberly Williams. She is our Deputy in charge in Newnan. Kim has been with the court for 9 years. Many of you probably know Kim or have communicated with her during her time as courtroom deputy for Judge Bezier. Next to Kim is Lori Davis. Lori is our quality assurance manager. Lori has been with the bankruptcy court for 9 years, but before that was at the U.S. Trustee's office in Boston, Massachusetts for 15 years. If you ever had a ECF account issue or filing issue, the likelihood is that you've spoken with Lori or one of her team members, Dan Newsom or Adrian Ashton, to resolve those issues, and you got detailed, clear, and precise instructions on how to fix those things. So the women to my right represent a combined 45 years of experience, knowledge, expertise, and service to the court. I like to think that we just brought a few of the clerk's office's best and brightest to shine a light on CMECF filing and CMECF practice pointers. We welcome your questions on the topics that we're going to cover. We're going to take some breaks periodically to address those, so we're not going to wait all the way until the end. Also, the presentation along with the slides will be available on the court's website, I believe under the Bench and Bar Committee tab after the presentation. There are many items that we can talk about regarding CMECF, many items, but we've managed to cull it down to just a few major subtopics. We're going to call those the agenda. No, the clicker is not working. For those on the phone, the clicker's not working. We're going to wait just a second to see if our IT gurus can get this working for us. Okay, thanks, Lee. So our three overarching agenda items are the online procedures manual, CMECF practice pointers, and the Chapter 13 plan. So Stacey, please tell me, what is this online procedures manual?
Okay, Vania, I will. Let me explain the purpose of the online procedures manual. The clerk's office and chambers run several different reports, pending motions, pending deadlines, calendars. I could go on. We run these reports to make sure that your documents are entertained efficiently. And all docket entries should be docketed correctly so they appear on the proper reports. So to help with this, we have created a resource, and even though it's still a work in progress, it's being, we add events to it, we maintain the events, change them when changes are made due to local rules. So it is completely updated daily, and it is a great tool for not only court personnel but for attorneys. It's named the Online Procedures Manual, sometimes referred to as the OPM, most often referred to internal by court personnel as the little green eye. This is a great resource with the latest and most accurate procedural information, and it should be the go-to for any questions. Now, there are 3 ways to access the Online Procedures Manual. The first way is on the Georgia Northern Bankruptcy website. You'll see it right in the middle of the page, the Online Procedures Manual. The second way is when you're logged in through CM-ECF, at the top of the screen on the category bar, there is an iProcedure section. Click on it and it takes you straight to the Online Procedures Manual also. Now, if you're logged into PACER via CM-ECF and looking at a docket, you'll see a little green eye at the end of the entry, hence the nickname Little Green Eye. And the little green eye will be at the end of every entry that has a section in the Online Procedures Manual. And it will take you, if you click on it, it takes you directly to that particular event and gives you all the updated information that you will need. Now, when you going into the Online Procedures Manual with option 1 or option 2, you will see a table of contents there on your left. The table of contents has all the major docket event categories. And it will, if you click on one of them, it will have a drop down with subcategories under or different choices, as you see here with the amendments with the different choices under it. Now, after using this, if you still can't find what you're looking for, use the search option. This is a great option. You can type in what you're looking for, and it will bring up all the events related to that particular option. Matter of fact, the truth is, when people get me on the phone and ask me how to docket something, this is what I use. It's my go-to. So this is a great tool.
Thanks, Stacy. So the second part of our agenda talked about CM-ECF practice pointers. You'll note that there are a number of bullet points here, and there is information in the materials that you have here and that will be available after this presentation that goes through all of the bullet points. We're just going to highlight a few just because there's so much information. Not that these are the most important, they're all equally important, but we wanted to touch on these during the presentation, but know that the rest of the information is available. Okay, Stacy.
Okay, let's see. Let's just start at the top then, and let's do the order distribution list, amendments to schedules, motion to vacate versus motion to reconsider, managing CM-ECF accounts, creating parties in CM-ECF, notices of appearance, and motion to substitute attorney. I really think that's all the time we'll have, but I encourage you to read the rest of the events and ask any questions because they are all equally important.
All right, Stacey, let's talk about orders on distribution lists.
Okay. Orders on distribution list. As we know, anytime that you submit or upload an order, a distribution list is required pursuant to Local Rule 9013-2B. And it's pretty self-explanatory. Now, we have this great tool that we've created. If serving all parties and creditors in the case, do not create your own distribution list. Attach a copy of the mailing matrix that is provided in CM-ECF. It will include the debtor, the trustee, the current parties, and all the current creditors in the case. Also, it is dated, which is a great reference point later if needed. You know, you can always go back and see when somebody made an appearance in the case and when your mailing matrix was dated, so that can really be a big help. So you go to Utilities in the category bar at the top. Oh, and this is free. It's a free. We want to encourage you to use our mailing matrix, so we've made it available for free. Under Utilities, go to Mailings and then to Mailing Matrix by Case. Again, this will give you the debtor, trustee, all the parties and creditors in a case. And as we all know, creditors and parties are changed constantly because of something being filed, notice of appearance, perhaps a proof of claim, so that in order to get the most current list, you must use our mailing matrix. And don't forget to prevent a new matrix each time you submit an order to not only get the current list, but to have a date on that matrix. You see here how to print it. This ensures that you are not only complying with the local rule, but that the clerk's office is clear on who needs to be served with each order. So this is a win-win.
Thanks, Steve. All right, next we're going to talk about amendments to schedules. We have just about two subcategories. So we have amended summary of assets and liabilities, and then the supplemental list of creditors. Kim is going to talk us through those and a couple other things.
Sure. Let's start with amended summary of assets and liabilities. Now, one thing that we all know this is required when filing your opening a case and you're filing along with your initial documents. But one thing that is commonly done, this document is missed when filing amendments to schedules and the monthly income statement. You're required to file this document when you're amending versions of the following forms on our list here on the screen. Let's just run through them. Schedules A and B, D, E, F, E, F, I, and J. And our last two on this list are very frequently missed, your Chapter 7 and Chapter 13 monthly incomes. Now, the summary of asset or liability is ultimately a detailed financial information type of form. So what you can keep in mind is that when you're amending dollar amounts in these forms, that's when you will need to file your amended summary of assets and liabilities. Now, also keep in mind that this form is required separately for non-individual and individual debtors, business versus non-business debtors. There are two separate types of this form, so watch your form numbers and make sure you're filing for the correct type of debtor. Now, a quick tip in the docketing process for filing this document, our ECF coordinators have went out of their way to include prompts in the docketing process. Don't let those big red letters pass you by because they really help you out. The questions that they're asking, if answered properly and correctly, can help you in the docketing process. Very useful to guide you through it. Once you complete the docketing process of amending your schedules or these monthly incomes, your final docket text should look something like this because it will ask you, have you added this form? And it will include in the docket text amended summary of assets and liabilities. So let's move on to another favorite form in amending schedules. Everybody's favorite is the supplemental list of creditors or amended list of creditors. List of creditors is what we'll go with. It's required when filing an amendment to Schedule D and F, E and F, or if you're adding creditors to the case. Now, this list must only include the creditors that you are adding to the case. Now, there's no CMECF event just for the list of creditors, so you need to make sure that you attach this to the document that you're amending so you won't run into things later trying to add it to the case later on. So let's talk about the bankruptcy rule that applies to service and additions to creditors. It's Bankruptcy Local Rule 9007 2D. It addresses notices to creditors that are being added by amendment. This rule makes it very clear that the debtor is responsible for serving any newly added creditors notices and pleadings that went out prior to the creditors being added to the case. When we are discussing the supplemental list of creditors, it is in addition to this local rule, because if you do not docket your list of creditors correctly and upload the creditors that you were adding, you take the risk of those creditors not being added to the case and not only costing you money later on because you may be responsible for serving notices or pleadings that those creditors may have missed for you not uploading them into the case. So let me mention again those prompts. Most of the prompts are big red letters, questions that it's asking you. It's great to answer those questions because it will also ask you when it comes to this supplemental list of creditors, will you be uploading your creditors during the docketing process or after? Now, the best way to make that decision depends on the number of creditors adding or your preference, just as long as when you're done and said and done with your document that those creditors have been uploaded to the case.
Thanks, Kim. All right, so let's talk about motions to vacate and motions to reconsider. I know that this is an area of great concern because we see a lot of folks who use the wrong event when they're docketing. So let's try to make it clear.
All right, so let's talk about the big picture here. You have 4 different motions. This screen is pretty much self-explanatory. You have 4 different motions: motions to reconsider, motion to reconsider order of dismissal, motion to vacate or order of dismissal. So the main takeaway here, and let me point out that personally I think this would be a great record screen to use in your docketing process or for the people in your office who are doing your docketing, because it kind of gives you a broad look as to help you make the decision as to which motion you need when. The main takeaways from here is whether or not the order you're considering, let's use that word, or requesting to consider or requesting to vacate, whether or not that order has been filed 14 days or less when you're trying to file your motion to vacate or reconsider. Another main takeaway here, and if you want to write this down, feel free, I can slow down. Another main takeaway here is if you're referencing an order of dismissal, that will determine which one of these motions that you file. Now, once you answer those two questions, now you get to the meat and potatoes that everybody likes, whether or not you're going to have to pay a fee. So depending on how you answer the other two questions can determine whether or not you need to start addressing fees, and you can address our fee table, fee compendium to decide whether or not you need to pay a fee. So at this point, let's break them down with some examples. Motions to reconsider. I'll go straight to the screen here. We're just going to go through the definitions, which I'm sure a lot of you probably already know. This is when a party requests that the court reconsider an order. This is one of those 14 days or less most events. Now, you cannot use this event if you want to reconsider a dismissal order. That's another event. You have some examples here. We gave you examples that are 14 days on the dot on this one, so you can see the use of this event. Now, if you want to reconsider a dismissal order, you will use a separate event properly titled Motion to Reconsider Order of Dismissal. As defined as before, a party requests the court to reconsider order dismissal, another 14-day or less event. Here's a prime example. This example, I think, gives you 11 days. That's where we come into the or less time limit. Now, moving on to motions to vacate. This is when the party is requesting that the court vacate an order. This is where we get into past that 14-day benchmark. You cannot use this event to vacate or order of dismissal. If we take a look at our example here was filed within 22 days. So if you want to vacate a dismissal, that's when you start getting into the money end of the deal. If you want to request the court vacate or order dismissal, and that order of dismissal was entered more than 14 days at the time this request is filed, there is a fee, and you would have to use the shown event here.
Thanks, Kim. Now we're going to transition to some questions, practice pointers about CM ECF accounts. As I mentioned earlier, we have Lori Davis here, who is our quality assurance manager, and Lori's going to address the CM ECF accounts. Lori, enlighten us, please.
Yes. So some of you may already know this, but I think many do not. If you change your employment, we need you to fill out a new registration form and send it to us. Your ECF account does not follow you, okay? So you may inform us ahead of time with an effective date of the change, so we'll have a new account ready for you when you start your new employment. You'll submit the new registration to the registration email located on the second page of the registration form. And the registration email is monitored by the ECF team, which is Daniel Newsom, Adrian Ashton, and myself. And you'll normally receive a response by the end of the same business day. So we'll set you up with a new account if that's what's needed, terminate your old account, but you don't bring it with you, okay, to your new employment. So all account changes need to be made by the ECF team. So a global change of address or email changes, you're going to email the ECF help desk. We'll respond by the next business day with confirmation that your account has been updated with the requested information. We cannot make these changes over the phone. You'll have to email us so we have it in writing. We save these emails for future reference with changes, and sometimes we'll get a call from Chambers asking when an address has changed. So this way we can, notify Chambers when this was an effective date. At the bottom of the slide, you'll see an email address for the ECF help desk and a link to the attorney registration form.
Okay, Lori, let's talk a little bit about creating parties in CM-ECF. And this is when you're actually filing something on behalf of a client.
Okay, so what we say is do not create duplicate parties, but what this really means is in most instances, you do not need to create a new party at all. Okay, so you're never going to create a party for yourself, and you're only going to create a new party if they're not already in the ECF database. Creating a new party should be a rare occurrence. So as an example, when you're filing a document electronically and the party you're filing on behalf of is not in the cases pick list for parties, you're going to use the Add Create New Party link, but instead of creating a new party, you're going to click Search. So to do this, you're going to type the first word or two of the company name or the last name and first few letters of the first name of the individual and click Search. Most likely you will find a name match. So for example, on this slide, there's no need to create another Home Depot. As you can see, there are multiple Home Depot accounts in the database. So you're going to choose one of the Home Depots from your search results instead of creating another party for Home Depot. So if you see an address match for Home Depot, you may select that party. If not, you can select any of the Home Depots with the same name and then just simply modify the address, or you can leave the address blank. If you're representing them, you're going to receive notice as their attorney. Do not add a care of you or your firm to the party address because you're receiving electronic notice. You don't also need to receive paper notice. So the only time you'll add an address for the party is if there's a specific address that you think should be served in addition to you receiving the electronic notice. And don't forget to select the party's role type for your case before submitting.
Okay, so what should we avoid when creating parties?
Okay, so when you're creating a party, if you need to, you do not add an email address for any party. The only email addresses that we should have associated with any party account is for an attorney who has a live ECF account to electronically file in our court. So no other party or attorney account should include an email address, so just don't add an email address. Also, do not use lengthy party names. Use the core name only. You can include lengthy name extensions in your motions and other documents you file, but for creating a party in ECF, the lengthy name extension will not fit. So again, enter the core name of the party only.
So Lori, what if, with the example that you have here, what if I decided I wanted to make the core name a little shorter, right? So if I said U.S. B&K, NAT, ASSOC, is that enough? Is that fine?
That's really not fine because I don't even know who that creditor is. I mean, you want to abbreviate only in certain situations if the core name won't fit. But generally, a core name of a creditor will fit in ECF in the name of creditor field. So.
Okay. Second, we're going to talk about notices of appearance versus motions to substitute attorneys. What's the difference? How do I use them?
All right. So a notice of appearance, you all know you routinely file these in cases where you represent a party and you want to receive notice. But there's also another situation where you can use a notice of appearance. And that is in a scenario where an attorney leaves your firm and someone else from your firm is going to sub in for that attorney. So when docketing this notice of appearance, prior to submitting the entry, just enhance the docket entry to include and substitution of attorneys. So when we review the notice, we will terminate the attorney leaving the firm and add you to the case. It's important to note, when we terminate a party or attorney from a case, the attorney will not be erased from the case. They will still appear on the docket or under the parties list, but they'll just have it terminated and then a date next to it on the date of termination. So that will be under the name. For all other substitutions, you'll need to file a motion to substitute attorney. So if you have consent, meaning you have signatures of the new attorney, the old or existing attorney, and the debtor. We can terminate the old attorney and add the new attorney without an order. If you represent a creditor, we only need the signatures of the old existing attorney or the new attorney. If you do not have all the required signatures for consent, you'll need to upload an order for us to terminate any of the attorneys in the case. If you need to file multiple substitutions, please contact the ECF help desk. We may be able to assist you with an easier or more streamlined approach to filing these. So just give us a heads up when you have more than one or two to file.
Okay. So I think this begins the slides that we're not going to cover, but that are available to you to use as a reference after the presentation. Laura, do you want to go through these, or
just the names?
We'll just go over the names.
Okay, so let's see. We have the notices rescheduling meeting of creditors and or confirmation hearings. We have the certificate of service of summons and complaints. We have the joint case docket entries, payment advices, proofs of claim, and then we get to what everybody is waiting for, the funny end.
So we'll take a quick break.
You want to take a quick break?
Just in case anyone has any questions, either live or on the phone.
Can you talk about the Schedule G and your creditors on Schedule G? Does those do not go to the mailing matrix, and how do you get on the mailing matrix?
You can if you when you file an amended Schedule G, if you file an amended list of creditors with that particular creditor on the list, we will add it. You will get the opportunity to add it to the case. Now there will be the fee, and so you have to docket because there's not a fee for amended G. But if you docket the amended list of creditors and include that creditor, there is the $31 fee, and we will make sure it gets on the case.
And what about on the initial schedule?
If it's on the initial schedule and it's on the matrix, you would have added it. I mean, you would have uploaded it with the.
And we just think we know that's a problem with a lot of attorneys not realizing the Schedule G, that those automatically do not go to mailing matrix.
Right.
And so those creditors are not getting notice of things.
And the same issue applies with Schedule H as well. With G and H, when making amendments or putting creditors there, in initial documents, you'll need to put those creditors in your matrix.
Right.
That'll put them in your ECF account.
Yeah.
And if you make amendments or add to, that's when you will use, not the event that we discuss here. That was technically what we discuss here is not an event. The supplemental list of creditors is a document you attach to your amendment. When you're amending G and H, there's a separate amendment that's amended list of creditors that you would have to use and pay the $31 fee to add into the case.
And see, a lot of people, sometimes they file amended G or they file G and they don't want that person necessarily in the case. So that's why it's not, so it has to be significantly stating by amended list of creditors that you want this party added to the case. Does that help any? Does that make sense?
Yeah, it's just, I'm the trustee of the fee.
Right. Yes. Yeah. Yeah.
People don't understand that there's another
right.
you have to do to get them on the mailing.
Yeah, because if they just file amended G or H, either one, and they don't file the amended supplemental, the amended list of creditors, they won't get uploaded. Those creditors won't get uploaded.
Hey, Jim, I got to turn broadcast mode on for the conference so that the people on the far end can ask questions. You want me to do that?
Sure.
Okay.
Okay.
Otherwise, they would have to text questions.
All right, but we can still take
We have
questions.
a lot.
Yeah, we got one here. Yeah, it is.
I'm hearing that, so we probably should have voters, vendors, because it's probably a software. Because if they're doing a thing where they know this, so it sounds like it would be a software vendor issue. And the vendors may not be aware, or they may not be sharing that information with the entity.
Well, I mean, I'm happy that Nancy brought it to our attention, so that way we can do some work on our end to try and clarify.
All participants are now in interactive talk mode.
It's not going to work.
Okay, Lisa, do you have can you wait 1 second, please?
All participants are now in listen-only mode.
Okay.
Anyone that wants to broadcast, anyone on the far end that wants to ask questions, you're going to have to text them in.
Okay.
Okay?
And we have one, but we'll take Larissa's question. Go ahead, Larissa.
No, you're filing it. You're going to file 2 events so that when you get to the pick list, you're going to pick amended Schedule G, and then you're going to pick an amended list of creditors that charges. It can be in one document, so it can be amended G and then the amended list of creditors behind it. Yes.
I think what's happening is because of the charge, I think they're saying, well, the file is, and I'm not sure if they don't take that next step, not realizing
Right.
it's not what they have to do to get it on the.
Yes. Right. Yeah, I think you understand that correctly too, because, and you know, if they, for instance, if you file an amended G and you have a supplemental list of creditors or amended list of creditors, and you didn't choose that event, it just happened to be attached, we will send a notice of deficiency and we will charge you the $31 fee. We'll assess the fee to your account. So that anytime there is an amended list of creditors attached, it has to be recognized with a fee.
But the court will not make that decision for you on Schedules G and Schedule H. If you do not bring anything to the court's attention that you are adding creditors via the cover sheet or adding those lists, you won't get a notice from the court or anything. We only send out notice of deficiencies on the list that we went today.
If you just filed an amended Schedule G without an amended list of creditors, we just don't do anything. Right. No.
Right.
Yes, ma'am.
So we have,
Looks like Alex has a question that we can click on.
well, and Angela has one too.
Okay.
So Angela's question is, when do you use amended creditors list versus supplemental creditors event?
And I think that's what we just went over. You want to get that?
Well, let me see if there's a question.
Oh, I just,
When do you use amended creditors? Well, supplemental creditors list is when, like, you're amending schedules.
Well, yeah, so you're only going to attach the supplemental list of creditors when you're amending D, E, and F, because that's going to charge you $31. You don't want to also choose amended list of creditors because that's going to charge you another $31. So when you're amending D, E, and F, you will just attach, without choosing an event, you'll attach the supplemental list of creditors to your filing. The only time you're going to use an amended list of creditors is if, like we were just talking about, you're amending Schedule G or H, and you need those, any party listed on those schedules, you need them added to the mailing matrix. You'll use amended list of creditors in that event. And then also the other time you may use amended list of creditors is when you're filing the remaining schedules for the initial skeletal petition, and you need to add creditors that you didn't already have in the case when you filed the skeletal petition. You'll docket your schedules and then also select amended list of creditors, so we can add, or you can add those extra creditors to the case at that time. Does that answer the question?
I think so. The amended list of creditors is when you need to docket it to charge, because the docket event that you used did not charge you the $31. Does that help?
no? It doesn't?
Okay. I want to be able to clarify it for you. So,
Well, I think of it more like this. There are docket events that you docket that automatically charge you a fee. Those that automatically charge you a fee are the events like Schedule D. Let's use that as a prime example. If you docket a amended Schedule D, you will automatically get assessed a fee. That's when you will use a supplemental list that is simply attached to that attachment. Say you're doing your amendment to Schedule G or your amendment to Schedule H. There is no automatic fee because you may not be doing anything that assesses a fee to those docket events. At that time, if you choose to do something that would normally assess a fee, as in add a creditor that needs to receive notices later, you would do the separate event amended list of creditors. Then you will be assessed a $31 fee.
So many cases will help on scenarios. One is I left the creditor off of my schedule. What do I do? And then let's say that I want to change the value or something. I'm not adding a creditor. I'm not changing the address. But maybe I said I owed them $10 and I really meant I owed them $100,000. Okay. So I have to amend my schedule to be correct. Okay. Then what would I do?
So if you're adding the creditor that you missed, that's when you will attach a supplemental list of creditors to that amended docket event. And let me stress that both of these changes in these scenarios assesses a fee because you're changing Schedule D. One, adding the creditor is when you would attach a supplemental list. Two, changing the dollar amount. This is where we stress that the cover sheet comes into play because you will need to put a cover sheet in the front of that amendment to explain what you're doing to it. But again, just amending Schedule D to change one dot over to the right is going to assess you to $31, but that second, just to change events and dollar amounts, does not require a supplemental list of credits.
and I'll just add to that when you're docketing an amendment to D, E, and F, if you're not adding creditors, it asks you if you're adding creditors during the docketing process. So if you say no, it's going to ask you why you're amending the schedule. So you'll type in a changing amounts or values on the schedule. And it won't ask you to upload creditors or anything. It takes you in a different path. So in both those instances, you'd use amendment to Schedule D, E, and or EF.
So this is just housekeeping. I don't know that the folks on the phone can hear the questions from the audience, so we'll need to repeat the questions. And then we have a question from Angela Wright, who's participating online. Why is there a fee to amend Schedule D if you're not adding a creditor? Sorry.
It's in the fee compendium, the miscellaneous fee schedule. Any amendment that you are filing to D, E, or F, it charges a fee. The only time it doesn't charge a fee is if you're adding an address for an attorney that represents a creditor or something like that. I don't have the miscellaneous fee schedule in front of me, but anytime you change any value, amounts on the schedules, you move a creditor from Schedule D to Schedule EF, or you're adding creditors. Any of those situations are going to involve a $31 filing fee.
So Angela, just to sum that up, it's because we have to, because the rules say we have to. Okay. Do we have any additional questions in the audience? Yes. Sorry, Dick Cavender.
I have a question with respect to updating your ECF information when you have a job change. I recently had a job change and got a new login, but I didn't do anything with respect to my old job. Do I need to do something affirmative to make sure that's done, or when I got the new one, it was already done?
Yes, I think that we took care of that for you.
Everybody else may not be that lucky.
Right. Let's clarify, nobody else will.
That's right.
That's right.
To you. Yes.
Okay. So if there are any other questions in the audience or on the phone, students have an opportunity to type their questions very quickly. We'll move on to the next.
I've got one up there.
I was going to say one thing that needs to be especially talking where Schedule D, let's say homeowners association address to be provided, they don't go back and they amend the schedule, they do a change of address. They didn't know if the clerk's office thought that was circumventing
Can you repeat the question?
Okay, so the question was, at one of the trustees' offices, they see oftentimes a creditor that might not have an address already in the case, but they were listed in the schedules when the case was filed, and they're using a change of address instead of an amendment to DE&F to add the address. And the answer to that is that's fine. Because the creditor's already listed in there, they're just providing us an address at that point. So that's okay to do.
Anyone else? And we'll have more opportunity to ask questions at the end.
So that's probably not the case because
Can you speak up, Monique? I'm sorry.
if there's a petition, this is HOA. Address. HOA is so the idea that we should say yes, that's the they have prior to homeowners association, and then later they provide an address ID.
Yeah.
We now this is don't say prior to homeowners association.
Right.
HOA.
Oh, no, that's not even the name.
Yeah,
Right.
if they filed a change of address that changed it from HOA with no address to, something HOA with an address, we wouldn't change the name. We don't change the name of creditors. That's not something that we do with a change of address. You cannot change a name of a creditor via a change of address.
No, but we would add them into the case with the change of address.
We would probably add the address.
Well, we would add the, yeah.
It would say HOA and then the address they provided. It wouldn't be the creditor name, whatever.
So which again puts you at risk that if you choose to go that route, you take the risk of things getting improperly noticed because your documents are going to be processed the way you submit them. So if you try to circumvent the system and take that route and use a change of address to change a name and slide your address in of that nature, it's going to it probably will end up getting added the way you put it, which will not, as Monique pointed out, help you in the long run when it comes to things that you're doing in the court.
So from the creditor side, though, if they have it goes from ABC Bank to NBC Bank, like we'll just file a transfer and assignment, they'll also try to just do it through a change.
And again, we don't change the name. The only time we would change the name of a creditor is when they've been able to provide us with some sort of merger document or something where a transfer of claims, they're not trying to run around that. So we wouldn't just go and change the name or even process the process that we would have them do a transfer of claim if there's a claim pending. But we don't change the name. So we have reached out to them in the past, different creditors, for them to supply us with documentation about any change in name in the situation surrounding that. So,
and if they provide it in one case, then would you do a global, or do they just file a transfer in every single case?
Every case.
Right. So the change of address would have that attached in every case. Yeah, we wouldn't do a global change of address for a creditor.
And that's one of those things where you have to. Right.
They would have to file that in each case.
Did that answer?
Any other questions? All right.
Okay.
Back to our agenda.
The plan.
Okay. My clicker is stuck. Okay. We can go ahead and we'll get there.
Okay, well, all right, so we're at the plan. We're going to discuss what is a flattened plan. We're going to talk about certificate of service versus a certificate of manner of service. and also the notice of hearing on confirmation of modified plan. So Linnea, can you tell us what is a flattened plan?
I'd be happy to. A flattened plan is, in layman's terms, one that cannot be edited. With the 12-1 rules changes in the official plan form, the court was able to use this product from Adobe called Lifecycle. And the reason why this is helpful is because it allows the plan to expand and contract so that you can add information throughout the plan. And we think it's worked well and it's very helpful, but what has to be done when you use that plan is that it has to be flattened. The two main reasons why these plans need to be flattened is, one, if you don't flatten the plan, it can be edited. So if you were to file a plan and it was not flattened, someone could potentially go in, download the plan, and make changes to it. And we obviously don't want that to happen. The second reason why it's important that you flatten the plan is because the BNC can't serve it. In the event that you file an initial plan contemporaneously with the petition and you don't flatten the plan, the clerk's office cannot serve it. The Bankruptcy Noticing Center cannot serve it. If that happens, you will receive an email from the clerk's office that says, you filed an unflattened plan. We flattened your plan for you, but you're going to have to serve this plan because we're not going to do it. So for those reasons, it's extraordinarily important that you flatten the plan. There are instructions here in the materials on how to do that, and we also have instructions on our website. I mean, shortly after 12-1, we pushed out information via Gov Delivery that explained the process of flattening a plan. So there are multiple places where you can go if you need a refresher on how to do that. The other thing I'd like to mention about the plan form is that the clerk's offices noticed that folks are amending the official plan form. What does that mean? That means, for example, in front of Chapter 13 plan, folks are typing in amended or first amended or second amended. That's not appropriate. If a plan, for example, is amended, then there's the checkbox in the top right-hand corner that folks are expected to check. So if you make any alterations to the official plan form, it is unofficial, and you run the risk of having that particular plan deemed ineffective or void on behalf of your client. So I think it's really important that we use the official plan form. Just last week, the clerk's office updated the plan form to fix a few technical issues and a few other issues. The most recent and updated version of the official plan form is on our website. There's also a notice that we pushed out indicating specifically what changes were made to that plan form. So please be mindful of, one, flattening your plans, and two, using the.
Sonia, I just wanted to mention too, when you're docketing the plan, when it comes time to attach the PDF of the plan, there are instructions, and they say stop. It's a pretty big stop in red, and it says remember to flatten your plan, and it gives you instructions right there. So it should remind you at that point also to flatten your plan.
Okay, next we're going to talk a little bit about the certificate of service and the certificate of manner of service. And at least from the docketing perspective, we'll try to clarify when it's appropriate to use either one of these docketing events. Lori?
Okay, so we all know a certificate of service is routinely filed to certify specific parties or creditors were served a document at addresses listed on the certificate of service. As contemplated by the general order regarding the Chapter 13 plan and procedures, a certificate of manner of service should be filed if you're serving a plan or notice where a party must be served under Bankruptcy Rule 7004. So this should be filed separately from the document being served and include the signature of the person who served the plan or the notice and the date and method of service for each creditor served, along with the name and address of each creditor. So when filing a certificate of service or certificate of manner of service, do not attach a copy of what you served. Instead, link to the plan or the document you're serving. This is different from when you attach a certificate of service to the plan you're filing. So if you're required to serve a plan, meaning the initial plan was not filed contemporaneously with the filing of the petition, or you're filing a modified plan, it will require a certificate of service. It may also require a certificate of manner of service. You may attach a certificate of service to a plan, and the docket entry will populate with certificate of service if you indicate you are attaching the certificate of service during the docketing sequence. Do not file the certificate of manner of service with anything attached. This should be filed separately and then linked to the notice or plan you're serving. And as Stacy mentioned previously, in order for the clerk's office and courtroom services to run accurate reports, we need you to select the event that matches the document you're filing. So do not select a certificate of service if the document is titled Certificate of Manner of Service. So just remember to title your document correctly. It's important, so if you're at a hearing and the judge is reviewing the docket and they pull up the Certificate of Manner of Service, and then they see it isn't a Certificate of Manner of Service, it says Certificate of Service, it may be a little embarrassing. So, you want to make sure that not only you, but your staff knows which event to use. It will help them select the correct event if your certificate is titled correctly.
Okay, so let's talk quickly about the notice of hearing on confirmation of modified plan and a deadline for objections.
Okay, again, as contemplated by the general order regarding the Chapter 13 plan and related procedures, you'll use this notice of hearing to reset a confirmation hearing on a modified plan that may materially or adversely affect creditors. This notice will require a certificate of service or a certificate of manner of service. If filing the certificate of manner of service, it should be filed separate from this notice of hearing. You can find this event under bankruptcy and notices, and the title of it is exactly the title of the form. Then we also have some helpful links for you. The Georgia Northern Bankruptcy homepage, the online procedures manual, the Chapter 13 plan, which was revised just this month, the ECF help desk email, the new registration form email, the actual attorney registration form. This will link you right to the PDF along with links to the general orders.
Thanks, Lori. So this concludes our presentation. We will open the floor for additional questions, and also if we need to stay after our scheduled time, and we'll be here to address those questions too. So on the phone or in the audience, if you have any questions. Make sure. All right. With that, I personally want to give a big round of thanks to the presenters. They've worked very hard in putting these materials together for you, and I really appreciate their efforts. So if you guys could please give them a round of applause, I really appreciate it. And thank you to Bench and Bar for helping facilitate this, and I hope this was all very helpful and informational. Hope you guys have a great remainder of your day. Thanks.